All right, it is 12 o'clock on November 9th, 2023, and we are going to get some information on trusts and LLCs. Linda Painter and Susan from RW Town Title are here with us today. If you guys have any questions, feel free to raise your virtual hand, type them in the chat, and we will get to those as quickly as possible. I do want to point out that this is 11/9/2023, and if you are attempting to watch this in the future, some of this information may be not relevant anymore. So if anything's changed, we'll take it down if it's drastic. If not, please ask Linda, Susan, and the wealth of people at RW Town Title for any updates on trust and LLCs. Without further ado, I turn it over to their trusting hands. Linda, go right ahead.
Oh, thanks. And Susan, if you have any input, just insert your ideas, okay?
Sounds great.
Okay, the first thing I think we'll talk about is trust and the requirements that is necessary for trust. And you do know your clients can purchase a piece of property under a trust. And the mortgage company, when they go to do that mortgage, they're going to want a copy of the entire trust. And we will also have to have a copy of that. And then we will run those on the title as a trustee and as individuals so that we know everything is okay with that. But we do need that battle trust, and we're also going to need a trust certification. And when they go to closing, they will be signing individually as well as a trustee on their trust on some of their documents. But it is very important that the lender does have a copy of that full trust. And when we get ready to sell, we again are probably going to need a copy of part of that trust that shows us who the trustees are and that there's been no changes or codicils added to that trust so that we know who has the authority to sign the deed. And
hey, Linda,
Yes.
you just used a big word. Can you tell everybody what codicils is?
A codicil is an addition to the trust and also to a will where they amended whatever the original document was. So that is going to be attached to that. And on a trust, usually it's amendments 1, 2, 3, 4, however many times they choose to amend it. And usually that's when they're changing trustees and they'll go with that. But an important part of all of the trust is that you know they can either go by, they can get a special tax ID number for that trust, or they can use their social security number. And that just depends on who has helped them set up the trust and for their financial information to go with that. But the most important part is when they get ready to sell, that trust has a bank account in the trust name. Because when we get ready to disperse the proceeds, it will be made to the trust and the trustees. It cannot be made individually. So they do have to have a bank account set up in that trust. And a lot of times they have to do that right before closing so that we can make sure that we are cutting the check and they receive the check within the trust name. And that sometimes causes heartburn for a lot of the clients because they weren't told they had to have a trust bank account. Now, when you're doing your contract and it's in a trust, always you will put it in the trust with a trustee on it, and they will be signing your listing and your contract as trustee of the trust of however they have named that. And that doesn't matter whether it's revocable or irrevocable trust. So I think that's all I really have on a trust. Do you have anything, Susan, that you might want to add?
No, that's all. Everything that you said covered it. And the sooner that we can get the trust information, we can obviously get all of that processed and gone through.
Right. America, you have a question?
I always give the instruction to my agents that the seller is not the trustee, it is the trust when they write it up. So to get around it in .loop, they just need to, when they add their people as sellers, they write the name of the person, the way they have to sign it. Okay, so, but when they auto-populate for the first time, there's going to be, it's gonna say them, they just have to backspace, put the name of the trust and the title, and then it'll go to all the other auto-populates. It'll be the trust will be the seller, and the signature will just happen in that loop.
Good. Yeah, because sometimes that is a problem.
Yeah, I
And
know.
if anybody
Probably
wants to
more
see that,
often than not.
and if anybody wants to see that in a video, if you shoot an email to training@rwtown.com, we actually have a YouTube video of how to set that up. So Haley can send that to you if you have a question. So just shoot an email, training@rwtown, and Haley will send the email link to YouTube for you.
One of the things when we have those trusts and the trustees, some of them may have passed away, then we have to have more information on that trust so we know who can actually execute our deed on behalf of the trust. And usually there's amendments that go to that trust that tell us that, who the actual trustee is. And then we also have to run that trustee. We still need death certificates and everything like on a normal transaction if there has been anybody that has passed away during that time frame. So we will need a death certificate so that we can prove that they really have passed away. All right, so now if no one has any other questions about that, the limited partnership agreements that we have, the LLCs, when people buy their property in an LLC, and they're either the sole member or a partner, it's however they set up that LLC. And it's got to make sure that it is a valid LLC and that they have gone to the state corporation and they have registered that LLC. And recently we've had some where the LLC now is invalid, meaning they have not gone to the state corporation and they have not paid their fees to have it reinstated as an LLC. And that's what we have to have happen as we go along getting that. So we're going to need, as not so much when they buy the property, unless they are using a lender. And a lot of times they use a hard money lender when they're buying these properties under an LLC and they're using it to do a flip on it. We still need the articles of organization for that LLC, their operating agreement, and that operating agreement is going to tell us who can act on behalf of the LLC. And there's a certificate of organization and a certificate of fact. And the fact is where they're going to find out from the state corporation that they are a registered LLC. And again, they can get a federal ID number for that, or it can fall under their social security number. But we have to run whoever is involved in that LLC to make sure everything is good. But most common problems we have is that they don't have an operating agreement and they don't know who can really sign. They think they're the sole member. Most of the time there's two members, 50-50, but only one of them was going to sign everything. And at that point, we need a management agreement telling us who has the authority to sign the deed and to transfer the title. And usually if they bought an LLC, they've also done some work to the house where they've improved it. We're going to have a list of what those improvements are and a copy of the building permit if it was required when they did this flip. And that happens on any investment piece of property, but it's more and more common when they have an LLC, and that's what their business is, to go out and to find houses, flip them, and then we need to know what they've done. They bought the property for $100,000, but they sell it for $200,000. We have to know what they've done to that property, so we'll have to have a list of that. And if a building permit was required, we need a copy of that building permit, because we want to make sure that there's no mechanics liens or anything like that that's still going to follow along with that title. Susan, do you have any other questions or additions?
No, but I appreciate you bringing up about the whole, whenever there's an LLC, we need the building permit, the MLA, because a lien can be put even for the simplest of what we think of as a repair,
Right.
we still need
And-
to make sure it is covered and paid for.
And recently, and some of these people now have held the property for a while, and we've discovered where they have not gone to the SCC and reinstated. They said, well, it's defunct. Well, it can be defunct, but title is still in the LLC, and they have to get it reinstated. So we have that, but also on the LLCs, we have usually, if they haven't paid cash for it, we do have a loan on that property. And a lot of times they don't realize when they go to a hard money lender, that hard money lender recorded a deed of trust, and we have to get a payoff on that. And even when they purchase with an LLC, that hard money lender wants tons and tons of information from them to get that money and get it through. And it has a high price of interest on those, and they have a very short time frame and what time to get all that done. But we do want to make sure that all the bills have been paid for to protect that buyer under the title. Does anyone have any questions about that? Okay. Usually on a when they're doing an incorporated or a corporation, really all we have to know is that the corporation is still valid and that ACC, that the CCC and everything's good on that. So doing corporations is a lot easier if incorporated or whatever. But you're going to want to make sure that when you do those listings, that you have the right partner signing that deed or that contract, showing that they have the authority to sell the property under the limited liability company. And that's when you're going to find out who the manager is and who the partners are and who has the authority to sign. So when you do your contracts, you want to make sure you have the right party that is signing the contract. And other than that, there's no really other title things that follow along with the sales contract. They all basically really say the same things. So do we have anything else on that? Well, Susan, we have some extra time. Do you have anything you want to add for the issues that we have coming up on estates or anything like that? If anybody has any questions on estates or
No.
anything like that.
With the estates and everything, we always have to make sure, for instance, with husband and wife, it's tenants by the entirety right of survivorship. But if both have passed, definitely urge your clients to get the appointment with the city to go to probate, get that done ahead of time so that we're not scrambling at the end. And so that's when some family stuff can come out where we need to make sure all the heirs are accounted for and such.
Yeah, and they do, when they go probate that, they have to get what is called a list of heirs filed. Not an affidavit, but a list of heirs.
Yes.
Because the clerks at probate, try to steer them in a different direction, but that will has to be recorded. Or if they don't have a will, then we have to have a list of heirs, and they have to go down with the death certificate, and they have to make sure that list of heirs has all heirs on there, because we have to run them a title to make sure there are no judgments or any problems against any of the heirs so that they can be paid off at closing. And that usually takes a while, and they have to get an appointment with probate, and they can't wait till the very last minute. And you know, we're getting a lot of contracts right now that have a short closing time frame on them. And if we have an estate, it's going to delay maybe if we don't have that will or the list of heirs probated, because then we have to go back to have it researched again. So when you're on a short time frame, and then when you list that, you're going to list it as the estate of, and then whoever the heirs are who have to sign. Now you're going to have somebody that says to you, I'm the executor of the estate. Maybe, maybe not. If there is a will, maybe the will said that they could be the executor. If there's no will, there is no executor. I don't care if they qualified at the court and saying they are an executor, they can't be one if there's not a will. And it seems like they're having a lot of these people qualify, as executors under this qualification at probate, and they're
Mhm.
not. If there was no will, they cannot be an executor. The will is the one who says who the executor is. And then maybe or maybe not that executor can sign. It depends whether they had the power to sell within the will. So if you have any clients that have have a will or anything like that, if you get it to Susan or I, we'll look at it to make sure that only the executor has to sign and not all the heirs. Because if there's no direction in there for them to get rid of that property, then all the heirs will have to sign. And that complicates things a lot at the very end
It
of our
does.
getting ready to go to closing.
But at any time, if you have a will, if you have even LLC docs that you want us to take a look at, we are more than happy to take a look and review it ahead of time to help you guys out and to give you the knowledge and everything that you need.
Correct. At any time, just give us a call and then we can tell you what some of the steps need to be done so that you don't have a hiccup at the back end of it.
Absolutely.
Tim, do you have any other things you think you want us to talk about?
I don't think so. If anybody has any general questions you want to ask, I think this is a great time to ask them.
We've been having a lot of things with judgments lately and how to locate the people.
Okay. Go ahead and tell us about that.
Well, if a judgment has been posted against someone and then it's a few years old, then whoever held that judgment or the attorney's office who held that judgment no longer exists.
Yes.
Then we have to do a lot of investigating to figure out who can give us that judgment payoff. The judgment doesn't go away because whoever filed the judgment is no longer in business. We still have to clean off that judgment, and it's a lot of investigation, and it takes a long time to get that all figured out. If we can't, then we got to turn the money over to the court and estimate whatever it is, the amount of that judgment. So most of the time we can backtrack it to figure it out. But judgments are on title for a very long time, so they just don't go away. IRS liens, we have to pay them. As you all know, they are highly top priority. They have #1 position on anything. And we have to get a payoff from the IRS to pay those off. And they can also be reinstated. That's up to the IRS of whether they're going to reinstate them. And I had one not long ago where the reinstatement was only a month away from our closing. Well, then the closing got delayed because the buyer's loan got delayed and the IRS reinstated the judgment. So then we're back to square one, having to pay off the judgment. So, and bankruptcies are a real issue, and I foresee them to be coming more in the future, only because, we have a lot of people using credit cards and a lot of credit cards, unfortunately, to pay off a lot of things. So if they go into bankruptcy, that turns the property part of the bankruptcy, and the court has to approve the sale of that bankruptcy. So they always have to get a court order for that. So hopefully in the future, that's not what's going to happen, but as time tells, that has happened before. And we know a lot of people have used credit cards to pay for a lot of things. Okay, Susan, you got anything else?
I can't think of anything because I actually had one that a judgment was reinstated exactly 1 month before it would have expired. And the property was deeded to the ex-wife, and now they don't have communication. So that's really a fun one.
Yep, that's what happens. Yep.
Yes.
All right, Tim.
All right. I appreciate you being here and sharing this great information. If anyone else has any last questions, we'll take it right now. Going once, going twice. All right. Thank you, Linda. Thank you, Susan.
Thank you.
Of
And
course.
Thank you,
Anytime.
guys.